Did you just get out of jail?
Yes, sir.
When? Okay, you didn't just get out of jail. When you come to court, come dressed appropriately. Shorts is not appropriate for court. It's a complete sign of disrespect. You understand? Okay, if you do it again, I'm gonna put you out. You're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. All right?
Yes, Judge. On February 3rd, 2025, at approximately 11:53 p.m., the officer observed a vehicle on a public road with a defective front left headlamp, and the officer ran a check on the vehicle and it returned with unconfirmed insurance. A traffic stop was initiated, and the defendant quickly exited the vehicle, and the officer gave multiple commands for him to get back inside and shut the door. The defendant stated he wasn't going to, and the officer had no reason to pull him over. The defendant then walked back and got inside the vehicle, but held his feet outside the car and did not shut the door. From the officer's trained experience, he has seen situations where the driver sit like that, then leap from the car and try to hurt officers, and the defendant put his feet into the car and the officer approached. The vehicle had 2 young children, but not a car seat, standing in the front passenger seat, and the officer asked the defendant several times for his name, and the defendant stated he could not because the officer was fucking with him. The officer informed the defendant of the legitimate reason for the traffic stop, and the defendant continued to refuse to provide his name. The officer asked the defendant to exit the vehicle, and the defendant then refused. The officer went to grab the defendant's wrist, and the defendant pulled away from the officer and other deputies. The deputies advised the defendant that he was going to be tased, and the defendant exited the vehicle. The defendant stated he wasn't going in handcuffs and resisted by tensing his arms and body and concealing his hands towards his front waistband. The defendant was taken to the ground where he continued to resist. After several commands, the defendant was going to be tased. The defendant finally put his hands behind his back.
And Mr. Collier, I'm going to find that there's probable cause to go forward with your case. Can you run his license to see if he has a valid Texas driver license?
I'll run it right now, Your Honor. It's eligible, Your Honor.
Mr. Collier, I'm going to find that there's probable cause to go forward with your case. I'm not putting any conditions on your bond. Just be careful. You get into a pissing match with people who have the power of arrest. Who's going to win? You know what I mean?
Sir.
Just, it's a logical conclusion. That's all it is. Just be careful when you're out there. Life's hard enough. As an African American in today's society, don't make it any harder, you know?
Sir.
Do you want to apply for an appointed lawyer?
Sir.
All right, I'm going to give you an application. I'll have you sign an receipt with Billy. I'm not putting any conditions on your bond. Just be careful. That's it. All right? Come on, man.
Rory Johnson.
Hold on, Billy, because I think Mr. Holt is. Are you ready?
Yes,
All right, come on. So you have Mr. Blanco.
Yes, Your Honor.
Hugo Blanco, come up.
Oh, you're going
Good morning, Mr. Blanco. Sir, you're charged with terroristic threat on a public servant. That elevates it to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
It's Judge. On February 3rd, 2024, the officer was dispatched to Eastside Transportation and made contact with the complainant, a bus driver. The complainant explained that she made an exception to her usual route to drop off a student closer to home. When the complainant was halfway to the student's home, she opened the doors to let the student off, and the defendant approached the bus doors and appeared to grip an area where his firearm was located at his hip. The defendant asked the complainant if she planned to write up his daughter, and the complainant said yes. The defendant then took a few steps back and lifted his shirt to expose his firearm while making threatening statements. The complainant was in fear for her life and did not want to come back to work, and the officer confirmed the incident by bus camera footage. And specifically, the defendant lifted his shirt to expose his firearm while continuing to make threatening statements, telling the complainant, "I got you." And then seeing the firearm, the complainant quickly closed the bus doors to leave, and as they were closing, the defendant lifted his shirt again to display the firearm, still repeating, "I got you."
Mr. Blanco, I'm going to find that there's probable cause to go forward with the case. Look, I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? As long as you can abide by these conditions, you and I will be fine. If I find that you pick up a new case, you have any kind of weapons, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Now you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because
Right out of the gate, the judge is testing credibility. Notice how quickly he challenges the timeline. That's a classic courtroom move. If your story doesn't add up in the first 10 seconds, everything that follows gets viewed with skepticism. Question for you. Do you think the defendant just slipped up or tried to play the court?
ducking and dodging and playing games, I will issue a warrant for your arrest. I'm not asking much. I just want my public to be safe. You understand? All right. So I'm going to have you sign a receipt with Billy. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right. You found no weapons, please.
No.
And then no contact.
No contact.
Yeah, please. Ready?
Rory Johnson, step up, please.
Coming up, Mr. Johnson. Right here. Mr. Johnson, you were charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present and be on the forward one. One will be appointed to you, sir.
Yes, Judge. On February 3rd, 2025, the officer observed a vehicle with no proof of financial responsibility. The officer also observed the registered owner of the vehicle to have an open warrant out of Harris County. The vehicle ran a red light and stopped past the designated stopping point, and the vehicle turned north, driving quickly as to elude the officer's patrol vehicle. The defendant pulled into a driveway. The defendant got out of the driver's seat as the officer attempted to initiate a traffic stop with emergency equipment for the traffic violations and conduct the investigation. The officer told the defendant to come to him, and the defendant began to evade on foot. The officer told the defendant to stop, but the defendant continued running, jumping over fences, before he was taken into custody. The defendant evaded for approximately 100 to 200 yards and was identified based on his ID and name.
What was the basis of the stop again?
So no proof of financial responsibility and running a red light.
Got it. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with the case. I'm telling you now, you're extremely lucky that this is a misdemeanor. This is your third. On a second, it's a felony offense. You're very lucky. Can you run his license, please?
It's ineligible, not eligible, Your Honor.
Have you signed an affidavit with me today, Mr. Johnson? I don't care what's going on in your life. Do not drive. Do you understand? This is an affidavit that you're going to be promising me you're not going to drive. If you want to drive, go get a license, get liability insurance, and I will take this restriction off. But if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do you have the ability to hire a lawyer, Mr. Johnson?
So
I'll have you fill out an application. I'll take a look at it to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Billy to sign a receipt, and then we'll take a look, fill it out. Don't pick up any new cases. Do you understand?
Sure.
You are lucky that this is not a felony offense right now as it is. So
Oh, yeah, what is this? Right.
do you have any THAs? Do you know? Hey,
Morning, may I approach?
what's up?
I was just in the neighborhood, so I thought I don't know if this is something we can do without my client, but I wanted to just check it while it's possible. I've got a young kid who's in high school, living at his parents' house. He's on house arrest with a laundry list.
I remember the one kid.
He needs to take his SAT test to try to get into college. That is March the 8th. I just wanted to approach and make sure
Okay with that.
you're kosher. Okay, that's
Yeah,
fine. Thank you.
Absolutely. Let them know, and for the time that he needs to go out, we're okay with it.
I know everybody wants to go take the SATs. But thank you, Judge.
Have to.
We did. We've all paid our dues. Thank you, Judge.
Absolutely. Marcos, you ready?
I'm waiting on
Not yet.
just a paperwork.
Not yet, you're on the paperwork now.
You have a few Marcos?
Yes, Judge.
The light here?
Excuse me.
Yes.
Who is it on?
One more chief.
Oh, is it the gentleman from the back?
He's
Oh,
right
he's
there.
out. Okay.
He's,
Did we do a TRAS?
yes, so he's been in custody now. Bottom line, Judge, the offer is 21 days, credit for 7.
I don't know if I'm gonna take a time served on someone who's got an open DWI in another county, and he's got a DWI here, and he's got,
It's not open over there, Judge. He's not open. It's not open over there. He's not open over there. And he told me he's reporting once a month. I'm sorry, once.
This is the formal shift from attitude correction to legal procedure. The judge lays out rights and potential penalties, but here's the key. Probable cause doesn't mean guilt. It just means there's enough evidence to move forward. A lot of people confuse that. Think of it as the court saying, this deserves a closer look.
To a week to some sort of a treatment over there. It's the 22-month probation in Tarrant County. And he lives in Tarrant County. His family's in Tarrant County.
signature.
Thank you, Judge.
So it's 22 months over there. His family's over there. He has to report. He was just telling me once a week to, I don't know exactly what it is. I'm thinking some sort of treatment. And for him to come down here constantly is just, it's not feasible for him. So that's why I thought, you know what, let's just close him out. Yes, he'll have 2 convictions, but he'll be in Tarrant County. He'll take care of that. He'll get, help over there, and then he'll be done.
You said he has how much credit?
He should have 7 days.
We did do a T-Rex though, right?
Yes.
What does the T-Rex recommend? I'm assuming residential?
Community, not, I guess that's different then.
Followed by IOP SSC, because they took into consideration because of the here immigration status and all of that. Because he was very so before and he didn't qualify.
Because of the immigration issue? Or what?
Because he lived in Tarrant County as well. The community residential is what they came up with.
I don't know, Marcos. Every time we deviate from that, it explodes. It literally just.
What if I find out? What if we reset him so I can get more information from Tarrant County and talk to his probation officer and figure out exactly what he's going to be doing over there? And then if it's similar to this and he's getting the treatment, then.
But this is residential. They're not doing this. Otherwise, he would be in it right now. I doubt that, because they already pled him, right? I don't even know if they knew that this thing was open. So they're just.
Sure they did.
I mean, I don't know. I mean, we can't speculate on things, right? Because it's just. Thanks.
Mr. Butler.
Mr. Butler.
Thank you.
All right. I mean, who's next one's a felon. I mean, he'll have to deal with that, I guess. All right.
Understand.
Okay, Mark.
Bring him up.
Yeah. You ready?
He does.
I need to Catherine.
Oh, sorry. Yes.
Did you read his motion to suppress?
I did. I'm sure Mackenzie did.
I was working in that.
I'm starting here.
Yeah, what's stone?
Mr. Martinez, let me tell you, you scare me. It's individuals like you that just don't get it, how dangerous DWIs truly are, because you continue to do what you're doing, and you may truly have a problem. I hope that you don't dig yourself such a hole that you will never get out of. But that's what DWIs are. Invariably, if it continues, at some point, you may eventually kill someone. It's not fair. Don't. If you're going to drink, if you're going to get lit, if you're going to have 32 beers, stay the flip home. If you have to go out, take an Uber. Is it so hard? All you have to do is push one button on your phone and someone will take you home.
Lo lleva a su casa.
With all the baggage that you have on your record
Lo que usted
now,
tiene en su expediente.
if you ever get pulled over
Usted
and an officer
This is where things spiral. Refusing basic commands, like identifying yourself, can quickly escalate a simple traffic stop into a criminal charge. Legally, the officer's authority increases with each act of noncompliance. So ask yourself, at what point does standing your ground turn into making things worse?
smells even one smidgen of alcohol, they're going to take you in. And from now on, you were looking at a felony offense of 2 to 10 in the penitentiary.
10 años en la
So if you don't get it now, perhaps prison
tal vez.
is what you need. You're young. You're going to be driving for the next 30 years.
Ando por los próximos
Get a clue. Do you understand?
¿Usted lo entiende?
Yes, Your Honor.
Yes, Your Honor.
The only reason I'm doing this now is because you're on probation for the next 2 years in another county. Otherwise, this would not be happening now. Take note and try to better yourself. It's not hard. All we're asking you to do is don't kill someone. Don't get into a car.
Yo tengo automóvil.
You're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done.
Esto por 7 días.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. It's going to be there for the rest of your life. Somehow I have to get through to you. What I'm going to do to you now is you will be required to pay the DPS fines and fees of around $4,500. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand? I am also suspending your ability to drive for a year. Do not get into a car. If I see you back in here, it's really not going to go well.
No le va a ir.
Do you understand?
¿Usted lo entiende?
Yes, Judge.
I'm not asking for much. If you have a problem with alcohol, address it. That's all I'm asking to do. I'm literally, don't kill someone. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a .15 or above? Okay, true to the enhancement. All right, Mr. Martinez, make us proud. That's all we're asking you to do. All right, let's see the clerk.
Thank you, Judge.
Thank you.
Better excuse me.
Yeah. 2-year payment plan. Did you read this motion to suppress? Read it. It's interesting. Yeah, take a look at it, both you guys. Tell me what you think. Well, I guess let's wait.
Your name, Rory Johnson? Is something from the old commissioners, Johnson, just contact us, your name? This is right here. Let's see.
Hi.
Good morning, Raquel Williams. It's a DWI. We just need to get medical records released. They're going to file the motion. I just wanted to approach to see if we can make note of it. It can be done in the meantime instead of when we come back for that release.
You mean,
There's
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it, I'll sign it. As soon as you file it, I'll sign it. So it's old though, it's 184 days old. Do you have an offer?
we're supposed to be trying to get PTI on it. She did a TRAS the last.
So first apply, don't just get the TRAS because, you know, there's a lot of changes that have been made. So I've seen more denials now. So
She's already done the T-RAS
Oh,
check.
she's already done it.
Yeah, I had her do it when she was here last time because her appearance had been waived, so
Tell me, is blood test?
it should be blood from, it was a hospital visit, so, yeah, there was blood.
That line right there, that's not just advice, it's a reality check. The judge is essentially saying, you might feel right in the moment, but power dynamics matter. In the courtroom, logic beats ego every time. It's blunt, but it's also practical.
It's like a point one.
What is it? What are the
Seven,
results?
I believe.
Yeah.
It's a part 1 7.
I'm curious to see whether she's approved or if she needs a mitigation packet.
It was 10125.
What is it?
125.
Okay, so it's not.
I do have, mitigation. I need to scan everything and send it over. I got, it
Accident?
was an accident. She ran into the back of a tow vehicle,
I think that you're
but still next.
still going to need it.
Right.
Like this, you know, they're going to want insurance and all that stuff.
Right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
I don't, a couple weeks is fine with me. I don't need,
So
I'll be able
what I
to
would,
get the
so can you
submit.
get the records to her today? Please file the motion. I'll sign it now. That way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks.
okay?
But the next setting, if you can have everything turned in, and then that way we'll wait for a response whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. Is can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance, right? Make sure she has car insurance. If she has car insurance, then I'm okay
Dad just
with
told
it.
me he
As long
put
as
her
the
on.
license is clear and she has insurance, I'm okay with it.
Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore? Sorry, can you confirm with her now? Does she have insurance now?
Dad replaced her on, I confirmed with him. He was here last setting with her and they were ready to confirm it then.
So they have car insurance?
It's not, let me find out if he actually, because I told him that last time, judge is gonna want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay.
Yeah. And then after that, if she does, let Felicia know, and then we'll amend the conditions to allow her to drive, and then just get a reset with Billy, and then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. And we can talk more about it if you want to.
No, I get it.
Yes, sir. And we back that, I'll show you from the years if you would like. We can take you right through that second.
I don't think, look, have you seen what he's talking about?
Yes, and I just spoke with,
And is it as in the motion, has he say, have you seen this?
That was a transcript.
the
Okay.
facts of the motion are as he said this. Yes.
What do you think?
I actually just spoke to Alex and said that case was recently overruled by
It's just that the Erdman case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No, this is Serrano.
But it cites the Erdman case. The underlying,
You talking about Simon? Didn't overrule Erdman.
they state,
No, it didn't.
and I would like to, we can read it together. I would like to share it with the court. And
Last I checked, a court of appeals out of the Sixth Circuit or something does not overrule the Court of Criminal.
this is the Court of Criminal Appeals, Defendant.
I'm sorry?
Finding is out of the Court of Criminal Appeals.
Okay, so tell me what it's, let's hear this.
1 second. So.
Obviously, we'll give you time to look at it so you can.
Yeah, no, it's still up to you. I've read fine.
And I would like to share it with you. So it says the rules developed by Erdman's progeny are contrary to the fundamental rules that determine whether consent was rendered voluntary. Importantly, these rules, like the analysis of Erdman himself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances. And
That's what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control the voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its
This is where the tone shifts from tense to dangerous. Displaying a firearm during a confrontation, especially while making threats, crosses into serious criminal territory. Even if no shot is fired, the intent and perceived threat are enough to elevate the charge. That's why this jumps to a Class A misdemeanor.
flawed reasoning and the flawed case law, but the result from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that, good law.
So, and I want to give you time to look at everything, right? But I mean, this is just like right on point with this.
100%.
Right on point, right? So if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's...
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, when the officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home.
Okay, so I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we?
Nope.
Yeah, we need to get there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please.
Why you have to move this out? Consider waiving her so much on that.
Yeah,
Yeah.
yeah. As long you can confirm. Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, a.m. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes.
That's true.
Okay.
We're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge. So just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside the statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're gonna get in the car and I'm gonna take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, you know that's not what's gonna happen. And Judge, and you know based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI.
This isn't just a lecture. It's a warning grounded in experience. Judges see patterns, and repeat DWI offenders are one of the most dangerous. Notice how the focus shifts from punishment to prevention. Don't kill someone. That's the underlying message. So here's the real question. Should courts be stricter earlier before it gets to this point?
DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing.
And if you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the body cam should be, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion. And the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the conclusion.
let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not
seen?
been overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, And that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail and, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. You know, they've already been waiting for, 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this
Well,
right after.
the only thing that
I don't want to keep them waiting.
No, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that there is no breath test.
Of course.
So I think
I guess we're ready to roll. But and then we can enforce.
I just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can.
Sure.
And then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the 2 outstanding case law that we have.
For sure. Okay. Any lawyers want to approach real quick before we bring the jury in?
Yeah.
Are you want to do your plea?
Yes, Judge.
Okay. Yeah, let's do it. All right, guys, if you're in the middle, we're going to ask you to please move over to the side because we're going to have a panel coming in and they're going to sit in the middle, please. So if you don't mind, please move it to the side.
I'm going to sign.
Yes, he's coming.
Huh?
I was hoping you could finish the brief.
Yes, no, we'll get it done today.